Good afternoon, everyone, and I'll try and make this as interesting as possible because, of course, lunch is sleep. The only thing I want to do after lunch is sleep. Now, I'm going to take this from three different perspectives and wear three different hats at the same time. Thank you. I'm going to wear three different hats at the same time. I'm going to wear an academic hat, I'm going to wear a practitioner hat, and I'm also going to wear a previous old hat, which is an institutional hat. So, three hats. Now, the first thing is the question, have I seen this before? From an academic point of view, you can't get away from it. Arbitration is made up of three separate sets of layers of law, and the soft law, which is the IBA rules on taking evidence, is almost similar as disclosure. It is the standard that is used internationally because of the difference between civil and common laws and the adversarial system. So there's no way we're getting out of it. So that's the academic side. I don't think I've ever seen any ICC arbitration procedure which hasn't put in the IBA rules of taking evidence as standard. I have never seen one. That's part of the terms of reference. It goes in. So again, that's from the institutional side. Now, as an arbitrator myself, I wouldn't dare dream of it. Why would I do such a thing? You know, not to use the IBA rules. There's no other, unless you're using the jurisdictional rule. But if you're in international arbitration where parties usually come from two different jurisdictions, then you want a system where everybody respects and understands and is absolutely clear. So definitely, from an arbitrator's point of view, I want to be using the IBA rules for taking evidence because I know everybody will have seen it. I know it's been drafted by a committee of people who are from different jurisdictions and their input will have been put in it. And because, back to the academic reason, you see I'm circling back in a nice little circle now. I know it's been thought about. Any problems that I could envisage will have been thought about. Of course, it doesn't cover all, but it's adequate enough. Anish?
Anish. Yeah. So I'll share my thoughts from a practitioner's perspective. Now, before considering whether I seek to put that in my procedural order, what I always do as a matter of practice, and very deliberately so, is schedule a 10, 15, maybe even a 20-minute call with the parties, either by Zoom or even by teleconference. The key behind that is to see and gauge the depth of understanding of the lawyers involved. Are they novices? Are they experienced? And additionally, how they conduct themselves, whether they're experienced or novices. Because what I've noticed is that in an ad hoc arbitration particularly, when you have lay parties, or rather inexperienced counsel, it's important because you need to remember what you can and cannot do as an arbitrator. It's not my job as an arbitrator to spoon-feed parties, this is what you're supposed to do, and handhold them throughout the way. But I'll insert the IBA guidelines in that sense if I notice, yes, they're a bit inexperienced, the lawyers involved, they don't quite seem to know what they're doing, they're they have this preconceived notion of evidence from a litigation perspective. But what's also important, as Tunde briefly mentioned, is knowing which jurisdiction or jurisdictions, A, the parties are from, but also, if you're dealing with a hybrid system of law, it's important to understand the potential implications of that. And just one example, for instance, and we'll talk about that in a little detail momentarily, but today I don't like one point in the IBA guidelines, which permits essentially parties to discuss a fact witness's testimony in advance. But that's a notion that's inconceivable in civil law. You can't do that. You should not do that because you're very tempting, entering into the realm of coaching, of unnecessary or too much preparation. The other point, very, very briefly, is it's important to keep in mind when deciding to incorporate. Now today, for instance, I will sometimes I won't use the IBA guidelines when I feel parties are very aggressive. Because, again, the IBA guidelines, hang on, one more. When they're extraordinarily aggressive, I tend to prefer leaning towards the Prague rules. The reason being, because the IBA guideline is premised on a common law concept, an adversarial notion, whereas if I feel parties are just so aggressive, I need to empower myself, subject of course to parties' consent to the contrary, empower myself to be more hands-on, perhaps more inquisitorial, which is what Prague rules would then offer. But again, I think the IBA guidelines, the updates were fantastic. We have one of the members of the drafting committee in the room, Professor Wahab. But again, like I said, certain things could have been done further, which we'll discuss momentarily. But yes, before you decide to adopt it, unless the parties put it in contract, understand your parties, understand, not your parties, understand the background of the parties, the system of law or laws involved, the lawyers, but, and this is a point that people forget, the potential jurisdiction or jurisdictions of enforcement. People always forget. They think, let's meet the requirements of the applicable laws, but you forget the jurisdiction or jurisdictions of enforcement. You may adopt a system, oh yes, IBA works perfectly. Hang on, this jurisdiction of enforcement is not going to accept that. This is inconceivable in that jurisdiction. So think about these points.
Thank you very much.
My follow-on was, Anish, what then happens when one party decides they want it and the other party that doesn't? Given that it's soft law and it's not mandatory law, what happens? And that's something we never ask ourselves as practitioners. What do you do as an arbitrator if one party wants it or not? And I'm sorry to put you on the spot, but
I've been faced with several situations like this where one party simply will not want it. And what you need to do as an arbitrator, okay, is be very weighted and measured, okay? And again, I'll give an example, but don't take this as a one-glove-fits-all. You need to understand a particular situation. If one party says no, they don't want to adopt it, what you need to do is essentially, in your procedural order number 1, okay, assuming it's a non-ICC case where it's not the terms of reference, but in procedural order number 1, frame it in a way. I like to be, when parties are in this manner, slightly more prescriptive in my PO1, okay? Not assuming that parties will know what to do, but I tell them, look, this is how we're going to take things forward, this is the timeline, and you covertly work in those core principles that you want to otherwise have, you know, assist the parties and make sure things move along in a streamlined manner. I would incorporate that in my PO1 without, of course, express reference to the IBA rules.
Yeah. And the point I wanted to make is, it is soft law. You can borrow from it, but you don't have to copy it wholesale. And that's the point of being soft law.
And sorry, just to add to that, there are some times where I've excluded certain provisions in my PO because I realized those would be inappropriate in the circumstances of that case.
Thank you, Anish. And now let's keep on the update that's been done on the version 2010. And let's focus first on evidentiary hearing, so Article 8. Article 8, I'd like to read in order to create a common ground with the audience. 8.2, it says that at the request of a party or its own motion, the arbitral tribunal may, after consultation with the parties, order that the evidentiary hearing be conducted as a remote hearing. So the topic is a remote hearing. That is a good trend nowadays after COVID. In that event, the arbitral tribunal shall consult with the parties with a view to establishing a remote hearing protocol to conduct the remote hearing efficiently, fairly, and to the extent possible without unintended interruption. And then there is the description what the protocol may address. So on that point, I would like to have some comment on the trend of the remote hearing and what is, according to your opinion, the most important element to include with the protocol.
Okay. Let's start with the word hearing. What kind of, I hope we're talking about the main hearing, just not a procedural hearing. And let's be evidentiary hearing. Let's be clear about that. And let me take you through an arc. And this is my personal arc. So maybe if I shared my personal arc. Because remote hearing is something which has always been in the wings, but most people didn't embrace because they thought a hearing meant you had a right to stand in a room to face your accuser, sort of a criminal type thing. But let's start in December 2019. I was still at the ICC, and the idea that you would ever had a remote hearing in a big case was just impossible. Come February, everything was almost shut down in the world. First thing we realized is the construction cases, the big construction cases, were not going to go ahead because they were fact and document heavy. Some of them had 30 witnesses. First thing I did was call around all the senior arbitrators who I knew were doing this kind of work. And the first thing they said, no, we're not doing any of that. Do you know what that means? I'll be looking at 30 faces on a screen. How am I going to do that? Everybody has to be in that room at once. I don't have a screen big enough to do that. 6 months later, all of them had 4 screens minimally in their homes. Yeah. Now, there's a cost to that. There's a cost to you and me in this jurisdiction where we have to do that. But that's not what you're talking to me about here. As we're talking to me about whether witnesses are going to be under control or whether, as Anish pointed out, they're going to be coached. So, what did they do? Again, this is my own personal arc, so it will be different for anyone. The big arbitrator says, oh yeah, we're not doing any of that. Until we sort it out, we're not going to have the hearings because we don't know how to safeguard it. Then you started seeing also different kind of protocols come in. Oh, this is what you should do, this is how you should do it. It didn't really deal with the practicalities of having 30 witnesses spread across the world. Every single lawyer in that room is in a different room. Yeah? The logistics were insane. But the smaller cases that were fact heavy didn't go along. The ones that were law heavy went. The ones that went fact stayed put, and everybody held their ground. That is an institutional ICC point of view. Of course, I left the ICC again during the pandemic. Don't ask, I'd already resigned before I realized that the pandemic happened. There was no going back from that. And I decided to be an arbitrator. So I had to step into the role of an arbitrator where my first case was done virtually. So I'm part of that generation, that those protocols became second nature. But of course, I'd seen it before at the ICC. Document-only arbitrations where you would have the parties briefly and get them on the phone. So those things weren't new to the uninitiated. But for most people who are coming new to arbitration, and for litigators who always want to dress up and go to court, and maybe in Italy you don't wear a wig, no? No, but you wear a gown, but no wig, no? And so you don't have the complete dress up. We do the full pantomime in the heat in Lagos. I never had to do it, but I remember once taking my father's dress shirt after work and doing that, and water came out of it in Lagos. The Lagosians will know what I'm talking about. The heat is terrible. But the point is, we had to get used to the procedures. And now that we are also used to it, in fact, some of us don't want to leave our homes again. We like our PJs, thank you very much. But the point of the protocol is that the previous rule for personal appearance has now been removed. We don't have those hang-ups anymore. Justice can be quicker. And so those protocols, we just have to make sure as arbitrators, because we control the procedure. That's something that must be clear to all of you who are aspiring to be arbitrators or who are arbitrators. You control the procedure. That means what he said, one shoe does not fit all. You look at all the protocols and use it to create your own protocol. Those protocols are like anything else. They're soft law, right? They're really soft law. You really use it. What is appropriate at that particular time? Is the person on the other side of the Congo River where the internet is not good? Yeah? This is the thing. I'm not making it up. Yeah? On two sides of the river in the Congo, one side the internet is good and one side is not. Do you take account of that when you're writing your first PO? Are you in an institution that has that protocol as part of its set of rules and they can help you with that? Or are you what I call doing real arbitration? And when I mean real arbitration, I mean ad hoc. Yeah? Institutional arbitration is, it's like having a Bentley and a butler. Ad hoc arbitration, you're pushing your ladder and you're the one that is going to repair it. You're your own mechanic. Yeah? Okay, that's the way I would describe it.
Yeah. So,
What do you think?
one of the biggest concerns that people had with remote hearing protocols was, how do you ensure no one's prepping the witness, no one's controlling, feeding the witness? And people had concerns, oh, it's impossible. I need to, when cross-examining the tribunal, we need to see this, etc. I've sat with many arbitrators who fought me very aggressively. There's actually two solutions, one of which extremely inexpensive, and one more expensive but gives a more hands-on experience. I'll explain. You can purchase on any web such as Amazon these small Bluetooth remote controllable 360-degree cameras. Very easy to set up. I mean, a 5-year-old child could set it up in their sleep. It's that easy. Seriously, very easy. You put them in certain parts of the room. That's step one. They cost about $20, $30. Really inexpensive, okay? Simultaneously, you may say, oh, look, Anish, okay, we'll put this, we can make sure. What if someone's prompting them on the screen? Again, you get some softwares free, okay? For up to 4 hours, in 24 hours it's free, and then you pay otherwise small subscription where you as the tribunal take control of that person's desktop. You see everything that they're doing. Each keystroke is logged if they're typing something. Again, so simple, so easy. Now, there was an arbitration where I was approached during the pandemic. There was a complex construction dispute, and this was involving 2 Japanese parties, very high values. And the Japanese were, look, we need to see. I said, I thought about it. And in that situation, again, to augment these concerns, because these were pressing disputes and they wanted to get moving along. So I proposed, look, since if you're okay with the budget, purchase augmented reality goggles, because Japan, but for that you need 2 things. A, it's an expensive initial investment, and B, you need everyone involved to have very good internet. Now, what augmented reality goggles, in very simple terms, is nothing complicated. Imagine wearing the Iron Man suit, the head in your cap, what you see. So if Tunde is, let's say, in Istanbul, and I am in Kigali, I can see Tunde's hand like this. You get the real feel, okay? The other issues that people have, so again, it's not difficult to adopt virtual hearing protocols to help the arbitration process. The other concerns people have, oh, Anish, but 68 bundles of documents is crazy. How do you expect me to keep flipping over? It's mad. I can't do that. That's an unfortunate mindset. I did an arbitration. In fact, this was an ICC arbitration, right? And we adopted you have this system known as virtual hearing managers, these live transcribers. They provide an entire service. And this was the first time I used it. And I was incredibly impressed, because what they do is, while let's say if Eugenio is the witness, and he's saying, oh, I remember writing in my witness statement this. Or the lawyer cross-examining, do you remember what you wrote in paragraph 10 of your witness statement? While they're speaking, the live transcriber flashes that paragraph on the screen, and what you as the tribunal member can do is fantastic. Let's say a tribunal of 3. I want to make certain notes and underline something, right? I don't want the others to see. They will not see what I'm seeing unless I press the button saying, let everyone view. If let's say Tunde is my other co-arbitrator, Eugenio is the other co-arbitrator, they want to make their own notes. They will make their own notes. It gets saved in their secure cloud, which they can access 24/7. Again, no problem. And this was a very document-heavy arbitration. The unfortunate mindset, like I said, and which is why some concerns I have with some of these virtual hearing protocols, I wish it just went one step further, just slightly, because I appreciate the need to not be overtly prescriptive when having virtual hearing protocols, is to alleviate concerns of, oh, look, it's impossible, you can't adopt this in complex disputes where you need to cross-examine 50 people. I said, no, it's not difficult. You just need to understand the technology. It's simple. I wish they just said, look, this could be solved with getting a small device. So people would have been less, perhaps possibly more receptive to those protocols.
Jumping on the other news that has been introduced by the GDPR impact. So even data shall be displayed also during the hearing witness, for instance. What about this topic? So, Anish, if you want to continue on GDPR impact on the rules that can be implemented.
Absolutely.
I also want you to address the privacy issues in taking over somebody else's screen, because that's part of GDPR, but that's what you need to do to ensure that you are in control. But as I said, an arbitrator must be confident and in
that
control.
You know precisely, that you know what you're doing. Because see, it's not a simple thing, oh, I control, I can move my mouse and open whatever I want on their computer. No. You need to be very cognizant with what you're doing. Now, dealing with GDPR, that's an interesting point that they brought about. But I think it's unfortunate that a lot of people don't understand the implications and what they mean by GDPR. Now, it's important to understand the technology involved in how it is stored. Okay? Today, people say, and I hear sometimes many institutions talk about, oh, we have this fantastic secure cloud system. I can tell you right now, there are only 3 providers in the world in terms of the technology that use true encrypted cloud mechanism, and this is what is known as end-to-end encryption. Now, what does that mean? Let's say if I get one password, Tunde's got one password, Eugenio, one password, right? What end-to-end encryption means, in the earlier example I gave, to log in to access those notes I made, I get one password. If I forget that password, that's it. No one on the planet can open that data. That's it. It's done. That is end-to-end encryption. When other people say it's encrypted, it's not. Because it's encrypted from here to here, so from me to the server, but the person who controls the server, if they get relevant permissions depending on where the server is located, they can access that data. Which is why today, a lot of individuals, and I'm very cognizant when I'm, especially in IP-sensitive disputes, always try and select a European Union server. Switzerland has become a big hotspot. Romanian servers, in terms of their GDPR controls, because today, for instance, people are very happy with these, I won't take any names for obvious reasons, but these major players of cloud service providers that almost everyone will use. Most of their servers are located in the United States, and that's very scary, because all you need is a federal court judge or a circuit court judge to say, no, disclose this data. They can just give all that entire data dump, forgetting whatever confidentiality requirements may be there, and you're done with, because the provider controls access. End-to-end encryption, only I have that access. So it's important to understand how that technology works. And in fact, on that point, I'd like to mention, since we have the Nigerian cohort over here, so the CIAB Nigerian branch does this excellent short course on how to set up your Zoom, your MS Teams in both for arbitration, mediation, how to control that data. It's very interesting, it's very exciting, so it's important to understand it. Today, for instance, if you're holding a virtual hearing, right, what settings do you enable in Zoom? What settings in MS Teams? You need to understand that, so I mean, I love the course that they did, so, and you have the 2 of the true trainers over here as well, so it's fantastic. Understand that, okay?
And Anish has covered GDPR, and I will cover the security side of it. And with data comes security, because these days data is king. If you have access to the data, then you have access to power. I'm looking for Diamana in this room, so that if Diamana is, the only thing the ICC sells is data. Simple as that. any institution, their core being is the data. The fact that they know how to do it. Now, even in an arbitration, data is key. How do you keep that data secure? As an arbitrator, how do you ensure that the party's data are protected if you're not on a secure institutional server and you're running an ad hoc arbitration? After all, what we're doing here, you're sending me an email and I'm sending you an email back. The documents exchanged by emails. How are you ensuring or determining the reasonability of the cybersecurity features and measures you're taking in your arbitration? Because it's expensive, cybersecurity. It's not cheap. What is the risk profile of the arbitration you're doing? This is another thing. Are you going to do extensive cybersecurity for what? $500,000 dispute or $100 million dispute? What are the existing arbitration practices and even the information security practices in your jurisdiction? Anish said we can have VR goggles in Japan. 5G is normal, but I know that if you put VR goggles in Lagos, no, the speed of the internet will not make. I know people use it too. I'm not knocking Lagos because people use VR. Is it? That's my question too. Is it really 5G? Because even UK doesn't have 5G. The UK doesn't have 5G, and that's just the truth of it. You know, you can say you have something. But as I always tell people, I won't say it in an English accent. The proof of the pudding is in the eating. Yeah? It's when you have to do something, whatever you say, you have to confront it with the reality of your position. That is where the true position. So what is the risk profile? What is the availability? Is it reasonable to impose this kind of security measures at extra cost to the parties? Well, that's interesting. What's your view about insurance and arbitration? Because that's the thing. We're going to get insurance now for cybersecurity?
No, so I actually had, there's a, you brought up the point.
Extra cost, but an extra cost. Extra risk, extra cost.
So you brought up a very interesting point. You know, how do you impose this? So there's actually a company, what's the name? 1 second. It's called IO Drive. So, something along those lines, right?
We shall Google.
So they are considered that you can create in your home. So I've actually purchased this but I'll only use it because it just takes some setting up to do for high IP sensitive disputes. So what this is, I have my private cloud in a little portable, like a little duffel bag. That device is fireproof. If you get the high-end one, you have it bulletproof encased. It can survive. It's phenomenal. And that company gives an insurance and guarantees that whatever is on that, based on the type of device you get, the very high-end or mid-tier, I just got the basic one for now, they'll insure that, whatever they is stored. You know.
What did it cost you? You have to tell us. You have to tell us.
Well, the one I bought was about, I think, $5,000. It's not too bad. But it's, like I said, it's something to consider. If you don't trust anyone, okay, there is another solution. Leave it entirely at that control. So then there's no confusion, where was your data stored? It's here in this one little fireproof box. And if you want to get the additional features, again, it's a subscription-based model. You make it fingerprint secure, you make it, or each time I want to open it, I have to put my thumbprint, I have to put a special code. You know, you can just add layers of security and completely in the arbitrator's control.
I'm going to add something to what he said, which is very good. It's one of my tenets in international arbitration. Paranoia keeps me alive.
I'm very, look, when I go to the ATM and I withdraw a slip, I don't tear it up, I burn it, which is why I don't smoke, but I carry a lighter with me. I burn an ATM slip, I'll never throw it away. You know, so you got to be cautious.
No, as an arbitrator, I spoke to one of my very good friends, and Jennifer Kirby, and I remember telling her this mantra of mine that, hey, paranoia keeps me alive. And she says, what a horrible thing to say, but I like it. Yeah, in the sense that your sense of responsibility on these issues as an arbitrator must not be neglected. Your parties are instructed you to take these issues seriously.
Absolutely, absolutely. Yeah.
If you're part of an institutional arbitration, the institution worries about it for you. You don't have to worry so much. Bless the institutions for that, as I said. An institutional arbitration is like a chauffeur with a Bentley. You're good. But ad hoc, you're driving your Lada and you're a mechanic.
And just to add to that as a supplemental, just a brief supplemental today, when you're acting as an arbitrator, like Tunde says, you need to be incredibly self-aware and conscious. For instance, post-2016, when I decided to be a full-time arbitrator, mediator, I think, and you may laugh at me, when I see a post I like and it makes an interesting thought, I will think 20 times, literally, before I decide to click like. Should I click like? What's the implication of the like? Who else has liked that picture? Where is this person original post from? What jurisdictions are they covering? This is what I think about. Because today that can be perceived. I remember a European arbitrator told me how they found out that one of the arbitrators on their tribunal was conflicted because they saw on their Facebook friends list a picture where the person was tagged, hugging shoulders with the one of the parties. Be very conscious. Today there are a lot of things I do that I don't do, being a full-time arbitrator, that in my previous Aftaras council I was more liberal about. So.
We went out yesterday and we were going to take a group picture that wasn't part of this conference as just going out to go and see a museum yesterday. And he quipped about this, actually. And now I'm seeing it. He actually quipped about this. I'm not sure about this picture. Nobody's going to post this picture, are they? And I thought nothing of it at that point. But imagine this is the life we live as arbitrators. Every single action we take is measured. It's not an easy life. It's not an easy life,
it may seem but it's a lot of thinking. And when you're dealing with issues of evidence, you need to keep thinking outside the box. Remember, you may hear something or read something in the books, or you may say, oh, this demigod of arbitration has written the preeminent treaties. They've not thought about this. But if you don't constantly evolve in terms of how you're thinking, you're never going to be a good arbitrator.
And read in all jurisdictions about what they do. Because again, you must remember that what governs arbitrations, what taking evidence, what evidence to exclude, is soft law. It's a lot of soft law. Yep. That when it gets to the court at the challenge end, which is where you don't think about it's going to hit you, it's going to bite you, and that's when you realize that soft law ain't that soft anymore. Suddenly it changes consistency and it becomes granite. And you're like, where did butter become granite?
Absolutely. And Eugenio, with your permission, one final example before we move forward to explain the importance of thinking about the jurisdiction of enforcement. Now today, let's take Indonesia, for instance. Indonesia is a signatory to the New York Convention. What does that mean? An award in a reciprocating territory, you can enforce it in Indonesia. Now, a lot of people don't know, Indonesia has a unique local law requirement which says that if the award in the first instance, even if the arbitration agreement specifies English, if the award in the first instance is not in Bettellai language, which is their local language, you cannot directly go to the enforcement court. You have to go to another court for quote-unquote official translation, which can take a few weeks to a few months. Now, the way to obviate that is you prepare a bilingual award, converting it into Bettellai at the local embassy, and now then you may think, oh, hang on, won't I now potentially offend the requirements of the seat? Simple solution. Add one line at the end. In case of any conflict between, the English language version prevails. You're then securing both at the seat, the applicable laws, also the jurisdiction of enforcement. That is why even when dealing with IBA rules, you can't simply think, yes, these are the parties, okay. Where are the potential jurisdictions of enforcement? You have to think about that.
And we used to call that pitfalls in the ICC. There were jurisdictions we had to do certain things. Or if we're in the Middle East, then it was not in the name of the Emir. If Indonesia, if it's in the name of the Almighty, the Most High. If that does not start your award, it's going nowhere.
Set aside, yep.
Yeah. And these are small, subtle things that you need to be aware of. And you wouldn't think of it, wouldn't it? If if your award in the Middle East does not praise the Emir, it ain't going nowhere.
And in some GCC countries, you need to start and end it in the name of Allah the Merciful, or your award is not going to be enforced.
So if I want to add something on the cybersecurity topic, and it's very sensitive because it's very actual issue, and for a doc in particular, because if you are an institution and you're covered by the chapter, if you're not an institution, you have to deal with yourself. So would it be a good policy? Thank you very much. But we have a good point. Would it be a good policy to address outsource to a tech company cybersecurity issue, and then to charge the cost to the parties with their agreement, of course. Because it's very difficult for lawyers to be so deeply on tech.
Look, both of us, we're doing the same thing. We're breathing in and out, considering it, and not liking the answer we're about to give. Everything is possible with the consent of the parties.
Yes.
Yeah, that's the short answer to that. The longer one, we'll talk over drinks in the evening.
But my preference would be not to outsource it. It creates more problems than solutions. I would not, like I said, you need to maintain as far as possible the integrity of the process. I will trust myself, hopefully my co-arbitrators, but someone completely a stranger, no. Sorry, no matter what guarantee you give me, I know that the level in which I will conduct that diligence and control, because it's my name and reputation on the line. The other person is just a business contract. Yeah, okay, fine, something happened. I've got insurance to cover me for it. For me, it's my reputation. I'm not going to risk that.
You as the arbitrator are responsible ultimately. That's the point. And you have to be responsible for the decisions you make, even though the parties force you into it. When it goes wrong, there has to be a head on the table.
Yes.
Preferably not mine.
Yes. No, mine as well, please.
Our last question, and very quick answers, even if the topic. There's a new article that says that the arbitral tribunal may, at the request of a party or its own motion, exclude evidence obtained illegally. So this is a big topic on assessment of evidences.
I'm gonna take this one quick and dirty. Ultimately, we're really talking about enforcement here. Yeah, ultimately. It's not about which evidence you take in, because I'm going to use an example here. It depends on the enforcement, because it will be a difference between the minimal and the maximal approach. And with the minimal approach, what will the enforcing authority do? Will they look at it in total, or will they just take a cursory view? Now, the maximal approach, and if you look at cases like European gas turbines, SA versus Westman, that's the maximal approach, which is sort of a French approach, which they will review every single thing. So they will look at that evidence as part of the whole consideration. And if you're an arbitral tribunal and you say, well, that evidence was obtained legally, especially if it's one about corruption, and it's usually about corruption, but it's in the public domain, but I can't import it. And then you render an award that goes contrary to that. That's public policy, and they will look at it and strike down your award, even though the evidence was obtained illegally, but everybody could see that that evidence was there. But in your mind, and in whichever jurisdiction you're in, now there's the minimal approach, which courts don't look at that evidence, and they just say, look, as long as the arbitrator has made a decision, it's done. But there's also a middle approach, and that was done in Solibashi versus Solibashi, where the presumption is that the arbitrator is sort of right, and we'll look at it briefly, and it's a two-step process. And if you look at Solibashi versus Solibashi, you get that two-step process. Is it likely that the arbitrator got it right? Yes. If the answer then becomes no, we'll look at it in a cursory view, not a detailed view like the French would do, which is the maximal approach. Yeah, and I've given you the West case for that. And that's the short answer to that. It's really about enforcement and whether you use your good judgment to consider the evidence in front of you. Because again, soft law. Yeah. And look at the mandatory laws of the seat as to how it treats evidence and how it treats evidential custody. That's it. It's a complex issue. And when we're talking about this, I think I should add this before Anish starts. We said to ourselves, well, we've all been stuck in the pandemic. We've been implementing these rules, but really, is there enough data to give you feedback of this? We could give you historical ways we've dealt with this over the last 10 years, and we've seen it done. But in the last 2 years, do we have enough data? And the answer is no. But we know what looks like common sense, because arbitration is common sense and a lot of good judgment.
Yeah. I was faced with an interesting situation once where, like I said, I always keep a poker face on when I'm acting as arbitrator, but one of my co-arbitrators in this case is a little more animated.
I would like to know the role of the parties to that rejection or admission of that evidence. That is, if the other party has not challenged that evidence, and we all know that arbitration still is a party-controlled system of ADR. If the tribunal goes deep into examining that the way that evidence was obtained, isn't it probably trying to go outside the will of the parties? Or isn't a tribunal can't it be seen to be acting on behalf of one party? I'm not sure if my point.
If I knew it was. Now, practical solution, right? There was an arbitration I was doing as sole arbitrator. I knew as a matter of fact that both parties had not referred to a very important legislative instrument. Very important. I knew for a fact that if I brought it, look, what about this? One of the parties would have lost their shirt. Okay, we challenge you, why are you advocating? I also knew that if my award did not have all it needed was a mention of it in the award, my award would be set aside for the asking. I knew that. So I sat for 4 days, 5 days, thinking there has to be something. So I said, okay. The parties must have thought I was crazy, but this is what I did. I issued a detailed procedural order asking the parties 58 questions. 57 were, pardon my French, utter rubbish. But they were very seriously framed. Now, the one question in between was the one I wanted the answer. But what I did was, I told the parties, look, I'll give the two of you 4 days, if that's sufficient. Please give me a joint response, a joint submission on this. If either party disagrees, please let me know, and I'll be happy to address that at that point in time. The questions were framed in such a manner, all the questions, even if the parties hated each other, despised each other, there could only be one answer. It was impossible to have, which is why it took me 4 days to make that, another 4 days to just draft that. I had to really think about it, And I got that reference in, put it in my award, and
I couldn't give a better answer than he did, but the only worry is, why did you just limit to 5 questions instead of that long? Because that is the only answer. That is what he's done is the only answer to it. The parties don't always agree, and you're not a mediator, but somehow you need to get something out of them. Now, the scenario he's painted is different from the one I had in mind, where the document is in the bundle already, but it was obtained illegally, but no one challenged the bundle. It is not your job to help the other side advocate. If they see the document and they allow you to use it as arbitrator, even though you sort of know they shouldn't have had access to this information, sort of your mind tells you, what do you do as an arbitrator? Do you jump up and down and, as he says, by pointing out that, advocate for one party saying, where did you get this from? Now, you can ask the question as a part of a series of questions that sort of teases out, but again, you'll be questioning the party and questioning them how they obtain their evidence. Again, a thin line to draw. If the other side has seen the document, you suspect it's illegal, the other side haven't raised it, c'est la vie, huh? Yeah, that's just it. But if they've raised the issue, that's what you're thinking, then you have to deal with it, and deal with it properly in the sense that, but by that time, you're past Anish's point where you've seen the documents, right? You have seen them as part of the bundle. It's not an extra document that somebody wants to bring in as a, how will I put it, the one that kills the other side as the deal breaker document. It's been part of that, but you know. So there are two different scenarios in what you say. And I hope Anish's answers helps balance out the approach, because the approach is what matters to how you deal with the issue.